The following is a local resident producers program. The program content is the sole responsibility of the producer and does not necessarily reflect the views or policies of CATV2, Oshkosh Community Media Services, the City of Oshkosh, or Time Warner Cable.
Everybody, welcome to Eye on Oshkosh. I'm Cheryl Hentz, and this is our very last political interview before the April 6th election. So I don't know if that's a good thing or a bad thing, but it is our last one. So we're very pleased to be joined this evening in this corner, wearing a brown or rather a blue suit. No, seriously, to my left is John Jorgenson. He is currently in the District Attorney's Office, and he is seeking Branch 5, which is being vacated after, I think, 38 years by Judge Carver. And to my right is Edmund Jelinski. He is a former prosecutor. He is currently in private practice, managing partner of your firm, I guess?
Yes, ma'am.
Okay, all right. And he is also seeking the Branch 5 judicial seats. So they've been on before. This time they're on together. So welcome to both of you.
Thank you, Cheryl.
Thanks for having us.
No bloody noses or anything like that tonight. So, but feel free to interact with each other if you want. Dan obviously is not here. You're in his chair, but he did send some questions, and I've got a question from a viewer as well. So we're just going to jump right into it here. A state lawmaker is actually vowing to introduce a bill to end Wisconsin's early release program. Scott Suter, he's a Republican from Abbotsford. He says the plan is a terrible plan, and it should just be done away with. How does each of you feel about early release? And is it a bad thing? Should it be done away with?
Well, I guess how I feel is that many years ago we went to truth in sentencing with the promise from legislatures that when a judge passes a sentence, we as a community, the victims, will know how long someone's going to be in prison, how long that person's out of the community, and we changed our whole system to address or to
adapt.
Facilitate.
To it?
Sorry, thank you.
Okay.
To facilitate that.
This is why I'm a wordsmith, John.
Adapt. That's the word I was looking for. And that was a good system. I mean, people knew when someone sent away that they're going to be gone for a while. But there were also ways for, even under that system, there was ways for the defendant to get out a little bit early. Good behavior, earned release. Also, there was a challenge in incarceration program. Well, now times are tough, and we have to admit that the state resources are down, and so now they're looking for ways to adjust that. And one of the ways they're doing that is through this early release program. My concern is we're just creating a whole new board again, another parole board, where bureaucrats in Madison are going to be making decisions that we entrust elected officials, judges, to make, because these are very important decisions when people are going to be released. So we created this great system called Truth in Sentencing, and now we're tinkering with it, and now we're really progressing back to the old parole boards where some bureaucrat in Madison were making the decisions. So I guess I personally don't like that.
So you're in favor of this not being repealed. You're in favor of continuing. No, you don't want early release.
Right.
You want them to stay in prison, maintain the truth in sentencing guidelines.
Right.
Okay.
I always say that it takes a lot for an individual to eventually progress to a sentence in prison. I mean, I sometimes feel like there's this misconception out there that the criminal justice system is just taking people, locking them up, and throwing them away forever. But haphazardly, and it doesn't happen. I mean, it's a progressive type of system, and either they have to commit a very serious crime, homicide, or others, or robberies, before they be sent to prison, or it's got to be a progressive thing, and it starts from misdemeanors to jail time to probation to eventually prison. So, you know, the people that are there generally need to be there, and I just think that by scrapping our whole system, that's not the way to go.
Okay, EJ?
I don't have a whole lot to add to that, Cheryl. Truth in sentencing is what it was intended to be, which is, you know up front exactly how much time you're going to be actually in the Wisconsin State Prison System and how much time you're going to be on extended supervision, which ends up being the new parole. But then to go back and make it more complicated and draconian again because of budgetary issues and everything else, you would think that there would be a better way to design a budgetary release for the system that would still be in keeping with truth in sentencing, meaning the offender would know up front at the time of sentencing exactly what amount of time was in and what amount of time was out. I think truth in sentencing wasn't intended solely for the criminal offender to be aware of how much time, but also for the victims of the crime and the community to be able to know exactly how long this person was going away. The problem that we had is that people were being sent away to prison, and they could be out in a year, they could be out in 6 months, they could be out in 2 years and 3 years, and there wasn't that feeling of safety and security knowing that that person was going to go away. There were nameless, faceless people out there who could release that person at any time. If the judge in the case says, this is the amount of time you get, that lends some security to the community. I don't think medicine ought to be tinkering with that.
So the early release then too. So you're opposed to doing away with the early release program?
I am opposed to doing away with the early release program as it is proposed and as it is being used, because I think it takes that surety out of the system that we tried to create.
You know, if I could add, I also feel like that under the old system, when people were sentenced, the judge would just say, I sentence you to 10 years prison. And I think there was an implicit understanding that people are eligible for parole. I think under the old system, I think it was a quarter of the sentence and mandatory release after 2/3. So I think there was this math made in people's mind of, okay, if I give them 10 years sentence, you'll probably get out in about 2 or 3 years. In the new system, I think that sentences have come down to recognize now that when a judge says, you know, you're going to prison for 2 or 3 years, that's the number that judge used with that consideration. So I think the numbers have come down for the amount of sentences, and now, if all of a sudden we're going to early release, it seems like we're going backwards and not forwards.
Some people in law enforcement, you know, talking about truth in sentencing, they think that truth in sentencing is nothing more than really a joke. I mean, but it sounds like you guys both feel like it's working the way it should for the most part?
I do. I guess I'd like to know in what context they believe it's a joke, but no, I think it works well, and I think it's a good system.
Okay.
Yeah, we both practiced in criminal law from the time of truth in sentencing's inception, and I don't quite know what the philosophical differences are with it. I think it works very well. Listen, you committed a burglary and you've got a long criminal history. You're going away for 7 years. 4 of those years are going to be incarceration and 3 of those are going to be extended supervision. And if you screw up on the extended supervision, you could go back for up to the entire 7. That's the sentence. It's simple. It's straightforward. The criminal offender and the community knows exactly what it means and exactly what's going to happen. Okay. So why make that more complicated and diffuse? I don't think it helps.
Well, obviously he wants to, you know, abolish this. Are there other laws that either of you feel are on the books right now that, for whatever reason, should maybe be done away with? Why don't you go first, EJ? I'd
be happy to. One of the laws that I've actually talked about this publicly quite a bit. One of the laws that I wish the legislature would amend are child sexual assault laws. There are child sexual assault laws on the books that are intended, and were intended by the legislature, to prevent adults who were pedophiles from taking advantage of children and from sexually assaulting children. The problem is that the way that it's defined, a district attorney's office, and I don't think the Winnebago County District Attorney's Office has been particularly bad in the way that they've charged these cases, but the law allows a district attorney's office to charge people with second-degree sexual assault of a child, a felony, if they're having a sexual relationship with somebody under the age of 16. And there are cases where there might be a junior or a senior in high school who's having a sexual relationship with a sophomore or a freshman in high school. And I don't think that those relationships are appropriate, and I don't think that the community should be accepting of a sexual relationship between two young children like that. However, to charge a senior in high school with sexual assault of a child under those circumstances where there wasn't any force or coercion or anything like that could impact that person's life for the rest of their life. And if you get a district attorney who doesn't understand that or doesn't care about that, you can ruin someone's life because two high school kids were having sex. That doesn't mean that we shouldn't be preventing them from doing it or criticizing them for doing it or not wanting them to do it. But the way the law is written, we've made it felonious behavior. And in some cases, felonious behavior that could result in the person having to be on the sexual offender registry as a rapist for the rest of their lives, when the facts of that case don't actually bear that out. And I wish the legislature would amend the law to say, or to make it clearer, that people who truly are child predators should be the object of this this particular felony charge, and not make it vague enough that we end up getting high school kids trapped into it.
Okay, all right. John?
That is a good point. And there is a lot of discretion in our criminal justice system, as EJ indicated. And I guess we trust our prosecutors to make the right decisions in those type of cases. And there are many ways of handling them without actually charging them out. So I agree in concept definitely with EJ that there has to be discretion used at that level. One area that I was thinking about that could use some tinkering or changes is right now when someone's charged with a felony, they have what's called their right to a preliminary examination. And it's a statutory created right, which means it's not required by the U.S. Constitution or the Wisconsin Constitution. It's created by the state of Wisconsin legislature. And I'm not against having the hearings, but I almost feel like it should be like a reverse waiver type of thing, where it's a request made by the attorney to have it as opposed to automatically having it. And here's why, because what happens now is someone's charged with let's say a sexual assault or a forgery or some sort of felony, and immediately it's set for a preliminary examination within 10 days if he's in custody, or 20 days if not in custody. And that doesn't give time enough, I think, for defense attorneys or prosecutors to sit down, talk about the case, maybe exchange some information, maybe work out an agreement. But what it does do is force the prosecutor to subpoena the witnesses, subpoena the victims, subpoena the officers to come sit outside a hearing. And then at that point, sometimes the prosecutor talks with the defense attorney if we have time. If not, it may just go to a hearing when it may be unnecessary. So I'm not saying do away with it, because I think there is some protections allowed to for the defendant. But I just think that it could be put off and make the defense attorney request it, and then if they request it, then it be set. I mean, I know some counties, and maybe EJ can talk to this, but I know some counties it's like automatically waived, like at least the time limits are waived, and then it's taken off the calendar for like a month or two, and then if there's no resolution between the parties, then it's put back on the calendar and they have the hearing. So I think it would save money for the system. Okay. I think it would save stress and duress for the victims, and in the end, the defendant's rights would still be protected.
Okay. Yeah, there have been a couple of proposals by the state bar as well as some legislation attempted by the legislature, which I think is appropriate, to say that you, as a criminal defendant in the state of Wisconsin, have the right to request a preliminary hearing if you want one. But it's not automatic. If you make the request, you can have one. If you don't make the request, you don't have one. And I think people who are and then you should be informed of that immediately when you're read the charges at your initial appearance, that you have the right to a preliminary hearing if you want one, where the state would have to put on evidence and prove, at least to a level of probable cause, that this felony was committed and that you're the person that did it. So I think you can still protect the defendant's rights by doing the reverse. Instead of having it automatic, make it a matter of right if the person requests it. I think that would be it would save a lot of money in the system.
Okay. What are the specific platforms that each of you is running on? EJ? Or who went first? You went first last time. John.
Okay, the platform. I guess my platform is about experience. First of all, when we run for judge, it's not about platforms in the political sense of like a legislator running for office where you say, I stand for this, I stand for that. Really, most things that judges can say is, hey, I'll do a good job, I'll work hard, I'll be fair and just, and here's my background, here's my philosophies on some issues that we can talk about tonight. But as for platform, I guess You know, I think it's about experience. I've been, you know, attorney for over 16 years. I've been in the criminal justice system most or all the time. I have some other experience in legal practice as a judge advocate general in the Army, but you know, I've been doing it longer, and I feel the type of experience, which is courtroom experience, jury trial experience, distinguishes me from EJ.
And John and I have been arguing about this over the last couple of weeks. You know, we both agree that there isn't a platform out there. I've said from the beginning of the campaign, if you want to change the world, go run for the legislature. Judges don't do that. Judges do the same things that they've done for the last 200 years. I think when people are deciding who the candidate for judge is that they want to support, I think they should take a look at experience and character. I think those are the two basic things that people have to decide on. I encourage everybody to watch this show. I encourage everybody to watch the Northwestern debate that John and I had, as well as the League of Women Voters debate that we had in January, and we'll have another one here in March. And you get a sense of who the person is, of what their qualifications are, and you judge it based on their character and who you think will be the best person to make a decision in your case if you ended up in front of them. John and I have a disagreement about experience. John has been an attorney longer than I have, but John has practiced primarily criminal law. I've had the opportunity in my legal career to practice criminal law, defense, civil litigation, property law, family law, probate, and just about every other type of law that an attorney can practice and have to do in the courtroom. John has done a large number of trials. John has done a large number of criminal trials. I've done criminal trials. I've done divorces. I've done tort actions. I've done trials in contract. I've done trials in tort. I've done trials in just about every aspect of the law that you can have a trial in, both to the bench and to a jury. And so I think that my experience is broad enough that if a person comes before me, if I'm elected judge, no matter what their issue is, I'm going to be able to thoroughly understand those issues in that law right away and be able to handle their case. And I think that most of the people who are voting in this election, well, John and I both agree that criminal law is important and is the majority of the court's duties. Both John and I have practiced in criminal law. We've both been prosecutors. I've done defense as well. But in civil law, which is where most of the people voting are going to come in, if you're having a fence line dispute with your neighbor, or you're going through a divorce, or one of your loved ones just died and you're in a probate action, I already know how to do that. And I think that's where the difference is.
Well, let me ask this then, because everybody who's ever run for judge has sat here and said basically the same thing. But if experience is so important, why is it that in this state, and I think in a number of other states too, you don't even have to have a law degree in order to run for and be voted in or appointed in to a judicial seat? Why is that? Because I think that's a little weird, if you ask me.
Actually, you're thinking of municipal judges do not have to have law degrees and are not lawyers. But no, for circuit court judges, like the position that EJ and I are running for, you are required to have a law degree, and the other requirement is you have to be practicing law for 5 years.
Okay.
Right.
Yeah.
The state legislature and the bar has said it, that if you're under 5 years, they believe that that's an insufficient amount of experience to run for judge. Over 5 years, they've set the bar as saying anybody over 5 years has a sufficient amount of experience from the standpoint of legally being able to handle the judge's position.
So distinguish for us then the difference between a circuit court judge, which is what you guys are running for, and a municipal judge. Because I still think when you have the title of judge, I think to not even have a law degree, that just strikes me as weird. Yeah. It really does.
I think the reason, or at least I think that the reason behind why municipal court judges aren't required is because municipal courts basically handle forfeiture actions. And forfeiture actions are civil actions. The difference between a civil action and a criminal action is a criminal action can restrict your liberty. The government can put you in jail or put you in prison. That's a criminal act. If it's a civil action, there isn't any sort of component of incarceration. And so a municipal court judge does not have the power or the authority to put somebody in jail for the ticket that they got, for a parking ticket or a speeding ticket or an OWI first. And so it's only a monetary charge that ends up occurring. And so I think that they've justified not having lawyers exclusively be municipal judges, because that restriction of liberty isn't really an ongoing part of the municipal judge's duties.
Okay. All right. Very good.
Right.
Okay. All right. Let's move on here. Now, each of you have a number of people in law enforcement, you know, be they officers or fellow attorneys, maybe even some judges, who have either endorsed your candidacy or made campaign contributions. And I know that this came up the other night at the Oshkosh Northwestern Forum. And I'm sure you guys can both see where having those endorsements would lend the public to think, you know, are they going to be biased when this person comes before them, if they do? And so with that in mind, a couple of things. Do you think that should someone who's endorsed you or made a campaign contribution to you, should they come before you, should you then recuse yourself? Or on a bigger issue or a bigger platform, if you will, should we change the way these kinds of campaigns, like judicial seats, are handled? Should we not allow endorsements and political contributions from people?
You're looking at me, so I will go first.
I don't care who goes first. I'm just looking at you.
You did handle the municipal law judge questions. I'll go with that. All right. Yeah, a couple thoughts. This is a big question with many different facets, but I think endorsements are important in a judicial campaign, in any campaign. You know, we want our judges to be from the people, be connected with the people, and be attuned to what people are interested in. And that is one way of doing it, by, you know, EJ and myself reaching out to these different groups and organizations. You're talking to them, you're not isolating yourself, and you know, you're making some connections and learning their values, and they learn your own values. So I think it is important for judges to be connected to the community. We also I think it's important that the community understand who stands behind each of the candidates. You know, we gave the example Tuesday night. You know, what if a candidate came forward and no one supported him? I mean, you know, he or she went out and just could not gain any support. You know, I think the public may say, there might be a reason for that. I think it may be telling that if you don't have any support of your fellow attorneys or judges or law enforcement or whomever, whatever group, that I think may be telling for the voters. And like I said, that's not the case in this race. And then one of your last issues that you just talked about raising money or recusing yourself. The Supreme Court, Wisconsin Supreme Court, has just made some judicial findings, I guess, or Supreme Court rules. See, the Wisconsin Supreme Court regulates judicial races and judicial conduct. And on the last Supreme Court race, there were these type of issues raised. And the Wisconsin Supreme Court did come down with a ruling. And essentially, I think what they said, maybe EJ can clarify, but I think what they said was that if someone makes a significant donation in relation to all your other contributors, then there is a per se conflict and you have to recuse yourself. So if one person gives you $1,000, whereas the majority of them are $20, $30, $40, then that's a significant conflict, at least an appearance of that, and you should recuse yourself.
Okay.
Yeah, you know, the problem that we have is, do you have judges that are elected in normal elections where you have to raise money and you end up having people contribute to your campaign, or should judges be appointed? Well, if judges are appointed, they're appointed by elected officials who had to raise money and campaign and are beholden to people from that fashion. I don't know that you necessarily can get away from the appearance of influence. Mm-hmm. I think, as I said in the Northwestern debate, it comes down to a matter of integrity and character. As I said, if a contributor of mine comes before me and the case should go against them because of the way that the law is written, it will do that, regardless of the amount of money they gave me. I also think, though, that certainly in cases of judicial elections, and I think that John would agree with me, the people that would contribute to our campaigns are people that we know, are people that are supportive of us, the people who are friends, who are our professional peers. And so, under those circumstances, there's probably going to be a large number of reasons why we ought to recuse ourselves anyway. And the money, that the $25 or the $50 that somebody may have given to our campaign, is probably going to be the least of those issues. Okay. Judges recuse themselves in the county, and the DA's office does all the time when you're dealing with people that you work with professionally, because there's the appearance of impropriety.
Okay.
And that is a good point. I mean, a lot of our fundraising things are families and friends, and you know, and a lot of attorneys, and on both sides. And you know, and like EJ said, it's a matter of integrity, and you got to do the right thing on every case that you handle.
Okay. All right. A couple of questions from Dan, and they're real quick. He says, first, as a citizen, I would prefer a judge who has some defense lawyer experience. It just makes me feel a little more secure. Your thoughts or comments on that? I mean, we kind of touched on that a little bit before, but...
Sure.
Well, he's absolutely right. Of course you'd want somebody with varied experience.
Yeah.
Listen, I've been both a prosecutor and a defense attorney, and I find myself in the unique position in private practice of in Neenah, Menasha, the municipal court. I prosecute for the city of Menasha. We did last year, and now I stand in for the city attorney on occasion. And I find myself in an interesting position of being on the prosecution side for municipal court on one day, and then on the defense side if I'm defending a client who happens to live in the city of Neenah. And so I'm switching seats all the time. I think the experience that I've had in criminal defense has been that my appreciation for the constitutional rights of individuals and for due process and for the system is greatly enhanced. You know, I don't have a mistrust of the prosecutor's office or the government, but if we did not have the constitutional rights and defense attorneys, and the prosecutors got to decide what to charge, when to charge, where to charge, and how to charge, and they were the only ones on sitting at that table, and it was just the judge and the prosecutor. Can you imagine, no offense to John, can you imagine the corruption that would take place very, very quickly if there wasn't somebody offering a check and saying, no, there are other facts in this case, or no, you didn't properly follow the rules in this fashion. And I think the fact that we do have a free society and that anybody in the world, anybody in the country who gets charged with a crime has to come before a jury of their peers and hear both sides and hear both arguments, I think is one of the greatest things that our system has. My appreciation for that due process is increased greatly.
Okay. John?
You know, I definitely agree with Dan's premise, which is the value of a defense attorney, and I absolutely recognize the value of defense attorneys. Our whole system is based upon it. As EJ said, I mean, we would be a kingdom with a king dictating down if we didn't have defense attorneys help us through the process. I mean, in fact, defense attorneys and prosecutors help formulate a lot of these laws and to protect the rights of individuals. So, I mean, I definitely agree with Dan's premise that, you know, defense attorneys are crucial in our system. But another part of his premise I agree with is that I think it is important for a lawyer who wants to be a judge, has worked with clients and understands their problems, their daily challenges, and their concerns in the criminal or the court system. As a judge advocate general in the United States Army, I was mobilized for 1 year, and I did have clients. I did help soldiers with their legal affairs. When they'd be mobilized, they would come to us and they'd have legal problems, and we had to take care of them before they go overseas to fight, because we want their attention and time focused on the fight. So I did work with clients on their family law issues, on landlord-tenant issues. They would oftentimes have problems with their landlords when they're leaving. I helped them with their employment law issues, because when they return from war, there's a federal law out there that guarantees that they cannot be discriminated against. And not only do they get their jobs back, but they get to be back to where they would have been had they never left their employment. So I also worked with soldiers to make sure that they were not discriminated against and held their hand through the system. So I do appreciate the premise of the question, and I do have experience working with clients and helping them through the process.
Okay. All right. Before we wrap up and run out of time, I want to get to this question, and I'm just going to read it. You both worked in the district attorney's office under former DA Joe Paulus. Mr. Jorgenson, you worked for him for about 6 or 7 years. Mr. Jelinski, about 1 year. I'm trusting these times are right. In the time that you were both working under Joe Paulus, Mr. Jorgenson, you were deputy DA. Mr. Jelinski, you were a recent hire. Mr. Jelinski, what was the atmosphere in that office that made you and Attorney Thomas Chalkoff and Officer Ann Gallner need to seek outside assistance in investigating Mr. Paulus? I think that's written not quite right, but I think you know where it's going. Or
is the question asking why did we start looking into
what was
Paulus?
the atmosphere in that office? I guess what was the atmosphere in that office that made the three of you feel that you needed to seek some outside assistance?
Well, I mean, I guess I can answer the question in a number of ways. First of all, you know, I worked in the office for a very short time, and the problem in the office was, and to John's credit, because I think John has been plagued with some of these issues for some time. John never took any bribes, and John is not Joe Paulus. And
no, I don't think
I'm
that
not running
what this
this
is
campaign
saying
against
at
Joe
all.
Paulus. It's, you know, I'm running against John Jorgenson, and certainly he didn't take any bribes. The problem in the office was that there was Joe Paulus had no ethics at all. Everybody in the office was kind of running scared of Joe because Joe was a very, very powerful, very vindictive person. And people in the office and in the system knew that there were certain attorneys who, for some reason, got reductions or dismissals of cases, and who got the personal phone numbers of the assistant DAs, and who could get deals on cases for their clients that nobody else could. And people in the office knew that there were assistants who signed stipulations to that effect, and that there were assistants who refused to sign stipulations to that effect and were punished for not signing those stipulations. Nobody knew why these attorneys were getting these deals, but we knew that they were happening, and they were happening on a regular basis. And looking at the cases, there was no reason from a prosecutorial standpoint of why those cases should be dismissed or reduced. I don't think anybody in the office imagined that he was taking bribes, but you know, why did these attorneys who were friends or who could have political connections, you know, people thought he was unethical and that he was doing this for gain of some sort. But I don't think anybody thought that he was taking bribes. I reached a point very, very quickly where I couldn't say to myself or to my family, I'm working for the good guys, when I knew that this guy was just awful and was completely unethical. And so I asked the question, why? Why are these deals being done? Why are people getting things that they shouldn't? Why, if you make a contribution to a calendar program or to a community service program, and you could afford to make $1,000 or $2,000 or $3,000 contribution, did you get a better deal than the poor guy that couldn't make that, didn't have that kind of money? And so I asked the question, and within a couple of months of asking the question quietly and wanting to find out what was going on with these deals, it became apparent that it was because he was for sale and he was taking bribes. And so then we went to the FBI because we thought, well, who else do you go to? You need that outside assistance. You need somebody to look into this that's not connected with the office in any way.
Okay. Well, I want to give John a chance to jump in here because there's a follow-up that they wrote specifically for John. It says, Mr. Jorgenson, what were your experiences? Were they the same? Were you unaware of some, or did you not have some of the same feelings that obviously Mr. Jelinski had? Did you know anything of what was going on?
First of all, you know, everyone that went through this ordeal has been horribly affected, and most affected is, of course, our criminal justice system. And since that day, I think all of us in the system have been working hard to win back the trust of the citizens, because without the trust of the citizens, our system means nothing. But specifically to answer that question, I think everyone that went through that ordeal and worked in the office has clearly a different perspective of what they saw and what they observed. You know, I don't agree with everything that EJ said or perceived. I mean, when he talks about everyone in the office running scared from Paulus, I mean, he was a difficult man. I mean, there's no doubt about that. But there are many difficult people out there that people work for. So, you know, I just see that as a poor characterization that everyone's running scared in the office. In the criminal justice system, we all, and I think we just talked about this earlier, have a lot of discretion on how to handle cases. I mean, I could look at a case as a prosecutor and say, well, I think this is a fair way to handle it. EJ, who has experience in prosecution, would look at it and say, no, I see it totally different. This person deserves this. And a third person could do the same. I've always contended that it's a difficult case to prove who was getting breaks and who wasn't. And to this day, I mean, that whole investigation had to deal with Sherlin and Paulus. And I think the investigation stopped short, for good or bad, probably bad, stopped short about all these other favors that were allegedly out there. I mean, as far as I know, that the Department of Justice report did not cover any of that other stuff. I had heard some people felt Sherlin was getting someone. I remember one attorney saying, "I want the Sherlin deal."
Mitch Sherlin for
right.
those folks who maybe don't know or are new to the area and still don't know. So,
or been, yeah, I think, yeah, right.
In which case, they might be better off.
Right, exactly. But to lay out, to prove who was getting the better deals and who's not, I still don't think has been established. And it would be a difficult thing to do, because I think you'd have to lay out every single case that was ever handled in that office and figure out why this was amended, this wasn't, because there were other amendments going on in the office. To say it was just happening for you know, some of the attorneys that EJ was referencing is just not true. I mean, other cases were handled, were amended, were you know, given breaks based upon the facts of the case.
Okay.
So.
Okay, all right. Well, I had some other questions, but they're going to have to just be forgotten because we're out of time. So anyway, thanks very much to both of you. Good luck to each of you on the 6th of April. And that is going to conclude our election interviews. Be sure to get registered to vote if you're not, and please go to the polls on Tuesday, April 6th. It's one of the most important things you can do. We're going to take a short break, and when we come back, we'll be joined by someone from the organization formerly known as our local Tobacco and Drug Coalition. We'll be right back.
Dear Mom and Dad, well, I finally have some time off, so I'm writing to tell you that I'm doing well. We have good days and bad days over here. We try to remember the good ones and get through the bad ones. Mostly we have each other, and that's what keeps us going. And Mom, since you asked, if anyone wants to help, just tell them to contact the USO. You can't believe how much they do for us. With love, your son, Michael.
Every year, the U.S. Department of the Treasury receives about 1.4 million reports of problems with paper checks. Checks can be lost, stolen, or delayed. If you still receive Social Security payments by paper check, Treasury wants you to know about a safer, more convenient way to get your money. The Direct Express Prepaid Debit MasterCard. The Direct Express card is new and is available to anyone receiving Social Security benefits, even if you don't have a bank account. Your monthly benefits will be automatically placed onto your card account each month on the day your money is due. While other debit cards cost money, it is possible to use the Direct Express card for free to make purchases, pay bills, and get cash at thousands of locations nationwide. There are no sign-up or monthly account fees. No more waiting for the mail or worrying about lost or stolen checks. Call 1-877-212-9991 or visit www.usdirectexpress.com.
We were in an emergency situation. We don't have extra. We have a little bit of water and a little bit of food. A meeting place, no.
No.
I don't think we have a first aid kit.
We have tuna fish, we have beans, we have canned tomatoes,
True.
you know.
That's true, but that's really not survival food. Tomato paste.
Yeah, well, yeah.
All right, welcome back to the second half of Eye on Oshkosh. Very pleased to be joined now by Emily Dieringer. She is one of the coalition coordinators for what used to be known as the Tobacco-Free and Drug-Free Communities Coalition of Winnebago County, and that is a mouthful, which is why I had to read it. They recently changed their name in December. I believe you guys changed your name, and it is now, and we're going to be putting it up on the screen throughout this interview because it's a little confusing, I think, just to write it, and I had to double check it. But it is rethink with an exclamation point instead of an I. Rethink your life, your choice, and that's the official name.
Yep.
Okay.
Yep.
All right. Why the name change?
Well, like you said, Tobacco-Free and Drug-Free Communities Coalition of Winnebago County is kind of long. practiced it quite often.
Yeah.
So that was one of the reasons. The second reason was that we started out as a tobacco-free coalition a long time ago, and then recently expanded when we got a new federal grant to focus on other issues besides tobacco prevention and control. So we got to focus on alcohol and prescription drugs and other drugs and that kind of thing. So we needed another name, but we weren't really sure where to go with it. So we just kind of threw one together and hoped for the best for a little while. But after a little while, it was kind of like, yeah, we really kind of need to start looking at something that's a little more concise, a little bit more about what we are, and a little bit more friendly to the public. Tobacco-free and drug-free seem almost kind of standoffish to the general public. It's kind of scary for people, and they're not really sure, like, oh, do I really want to talk to those people? They're for drug-free and tobacco-free, and maybe I don't necessarily believe in that kind of thing or whatever. So we wanted a new name that was fresh and appealing to youth, but still eye-catching and more appropriate for everybody. So rethink was a collaborative effort over several months, lots of discussion. But we're really, really happy with it. And when people are asking, well, what does rethink? What's that? Then we say Winnebago's Healthy Living Partnership. And that really kind of explains a little bit more about what we are and kind of goes back to our roots with the tobacco-free and drug-free aspect of it.
Okay,
So.
all right. So for people who don't know either what rethink does or what that long name did when they were in existence, tell us a little bit about what you guys do.
Right. Well, like I said, we're a healthy living partnership. So we're based out of the Winnebago County Health Department.
Okay.
We serve all of Winnebago County. Many of our efforts and our activities are directly in Oshkosh because that's where most of the people live. But we do also do things in Neenah and Menasha and Winneconne, Amarillo, I know the outlying areas of the county. And we work on tobacco, alcohol, and drug prevention and control. And that basically means if you never started, we don't want you to start. If you're underage, we don't want you to use. If it's bad for you, we don't want you to get involved with it, and we want you to make positive choices in your life. So lots of different things. We work with lots of different partners. We work with the Oshkosh Police Department. We work with other area health departments, non-for-profit organizations, youth-serving agencies, churches, schools, those kinds of people, and then general community members. Also volunteer for different activities that we work on and different efforts that we're involved with.
Okay. Now, because you serve Winnebago County, Emily, does someone have to be a resident of Winnebago County in order to get help from you guys?
Not necessarily, no. Usually, we usually go with either you live or work in Winnebago County. I personally live in Outagamie County, so I don't live in Winnebago County, but I still do a lot of things in Winnebago County. So that's really important that it's a community focus, and the definition of community can vary depending on what we're working on. So.
Okay. And what is your target audience, if you will? I mean, obviously you serve everybody, but is there a certain demographic that you're trying to reach? Like, are you trying to make a concerted effort to reach the younger people to keep them from getting involved in drugs and tobacco?
Yeah, it's kind of twofold. A lot of our efforts focus on the youth because a lot of our things that we do are prevention efforts, and the best way to do prevention efforts is to start with the youth because they'll grow up not being involved in those kinds of things. But it also works on the other side with the adults because kids grow up seeing adults doing certain things that may or may not be appropriate or may or not be healthy for them, and they'll grow up knowing that, oh, that's okay or that's not okay, or, oh, my mom and dad don't smoke, so I'm not going to smoke, kind of thing like that. So it's kind of twofold. We work on the youth side, but then we also work on the adult side with the modeling and the learning good behaviors and changing those social norms from the top down as well as the bottom up.
Which is the harder of the two to work with? Is it harder to break habits that someone's had for potentially a very long time so that they can become a good role model for their children, or is it harder to reach that child if their parent, for example, does smoke or abuse alcohol or abuse drugs?
Right. It kind of And not that I've been doing this a very long time. I've only been working in the coalition for about 1.5 years, but I don't think it's necessarily age difference. I think it's more of the subject matter and what you're talking about.
Okay.
And I mean that by the cultural norm and the attitude towards tobacco has really changed in the last few years, where it's not cool to use tobacco anymore. Like, most people know that tobacco is bad for you. They know that it's not cool. As opposed to an alcohol type subject where, oh, we live in Wisconsin and that's just the way of life and that kind of a thing. So it's more about the attitudes around the substances as opposed to the actual ages of the people that we're working with, which is kind of interesting and a different animal to tackle it sometimes.
Yeah. Well, you know, you talk about smoking not being cool, and I would agree that a lot of kids have that mentality, and yet, you know, if you drive by one of the high schools, either west or north, and you see the kids who are smoking, they really act like they're something special, you know, as they're dragging on that cigarette and passing it around, and you can tell it's a cigarette that they're passing around, not something else, but they really think they're something great.
Yeah, it's interesting because you know, you look at the statistics, and less than 1 out of 5 high school students smoke. So it's right. The state average right now is at 17% of high school students use cigarettes. And you ask those kids, well, how many people how many kids do you think smoke? And they'll throw out 50%, 70%, you know, all these really high numbers. And then I tell them, well, no, it's really less than 1 out of 5. And they're just like, what? Well, it's because all of their friends smoke, and they hang out with their friends because, well, their friends smoke and they all have something in common.
Sure, and that's why the number seems bigger.
Exactly. You know, you see 10 kids standing on the corner. It's like, well, yeah, okay, there's all these kids smoking and they think they're all cool, but then you don't see the 90 other kids not smoking on the corner. They're inside, or they're doing whatever. So you just don't notice that, but yeah, that always blows my mind, is the kids have this wrong perception of how many kids actually use tobacco, and it's a lot less than they think. And when they hear that, it's kind of like, oh, I'm not in the majority. Yeah. And then they kind of get that, oh, I guess I'm not. That's not as cool as I thought it was.
I mean, we could talk about there's so many different facets to this whole thing. You know, you got drugs, you got alcohol, you got, you know, cigarettes. There's so many things that we could be talking about, and we just don't have time for all of it. But when you talk about cigarette smoke and so forth, there's, you know, a big piece of legislation that's becoming law. Well, it's law now, but it hasn't gone into effect yet, and it is going into effect. Is it July 5th?
July 5th, 2010.
That is when the tobacco-free law goes into effect, where you cannot smoke in a public place in the state of Wisconsin. The only thing that I think is accepted from that, and we talked about this a little bit the other day, is the casinos.
Right.
Because they're sovereign nations, and they can kind of do what they want.
Right. Right. State government cannot tell them to regulate their tobacco.
It would be
smoke.
nice if they would, you know, do away with it.
We would love that. They would be our friends.
You know, what have you, as a coalition, if you will, been hearing from folks about the ban that's about to go into effect? Are there questions out there that you're hearing, or what are you hearing?
There's definitely a lot of questions out there. Most of the reaction is oh my gosh, I can't wait. That's the number one thing that I've been hearing. I can't wait till we go smoke free. I'm so excited for July 5th. I can't wait to go out to dinner and not have to smell like an ashtray, or oh my gosh, so that's most of the positive things. A lot of people have questions about enforcement. It's generally a self-enforcing law. People are all, you know, concerned about, well, you know, are you going to pull the police off, you know, some other call to go write a ticket for someone who's smoking inside a building? No, we're not going to do that. You know, it's everybody's responsibility to enforce this law. So that's a lot of people's concerns. And then there has been some kind of talk about potentially a sort of a loophole in the law with possibly people being allowed to build smoking rooms that technically meet the definition of non-enclosed space. So it's really kind of concerning, because that law language is subject to change, and we don't want anyone to be investing in some sort of addition to their business when in fact they wouldn't be able to allow smoking in there anyways. So those are some of the concerns, but overwhelmingly everyone's just really, really excited and can't wait for July.
So people, I guess the word to the wise is people should not go looking for this loophole and then rushing out to build an addition onto their existing business to allow smoking in this little special room.
Yeah.
You know, the unfortunate thing of that for some businesses is, as you probably know, we went smoke-free in Oshkosh as far as bars and restaurants and so forth. I forget how many years ago it was, maybe 5 years ago?
Yeah, 5 or so.
Something like that. And there were some places, one in particular that I can think of, that is an old established restaurant in the city, and they actually did go to the time, the trouble, and the expense to build a special room equipped with all the things necessary to allow smoking in there. And now that will probably be all for naught. Really.
Right. That won't be allowed. They won't be allowed smoking in that room anymore. And really, it's a public health law, and it's intended to protect the health of all of their workers as well as all of their patrons against the dangers of secondhand smoke. So it'll be great for all the employees out there that have to work in those types of environments, and great for all those patrons that go to those places that don't have to expose themselves to secondhand smoke anymore, just to have a nice meal, or those employees who are just working to earn a paycheck. So
yeah,
it'll be great. It is unfortunate that some businesses went out of their way to try to accommodate smokers, which was nice at the time, but we're really excited about this public health law and be able to do some of those preventative measures to make sure that people aren't exposed to secondhand smoke, because it does cause cancer and it is dangerous to people's health. So.
What what level of activity has your organization taken part in with a movement such as this statewide initiative?
Oh, lots of different things. Our coalition, talks to legislators. They educate, boards of health or the city government. It's really a lot of education and making sure people understand the reasons behind it and the science and the facts, and just talking to people and gaining their support, talking with businesses and making sure that they know what's going on, and anything and everything we can do to talk to people and gain more support for things. We work with schools and explain it to kids, so then they understand that, oh yeah, that's awesome, and they'll grow up not knowing that, oh, you used to be able to smoke in restaurants. They'll grow up not knowing that ever occurred, and they'll look at you like, oh my gosh, you used to be able to smoke in a restaurant? What? Yeah. So yeah, so that's great, and those are the types of things that we do, and we work with all of our community partners, not just on tobacco issues, but on alcohol and drug issues too. So
one of the things we had talked about that you wanted to say something about tonight was the tobacco compliance checks. What are those? I mean, I think I know what they are, but I'm not entirely sure. So why don't you tell us and me what that is?
Right. Well, we do alcohol compliance checks too, but what basically the compliance check system is we work with local law enforcement and volunteer youth, and we go to establishments that either hold an alcohol license or a tobacco license. We send underage youth into that establishment. They attempt to purchase the product, and if they do not get a sale, so the clerk denies them the sale, we congratulate that business and say, hey, way to go, thanks for not selling to our minors, because that's illegal, and good job for doing what you're supposed to be doing. And if they do get a sale, the clerk sells to them, then our officers will go in and cite that clerk for making an illegal sale.
Does the clerk get cited as well as the business, or is it just the clerk?
Generally the clerk gets cited, because if they've been trained to if you're selling tobacco, you need to be 18 and over. If you're selling alcohol, you need to be 21 and over. They should have been trained in that, and then that's their fault for not complying with the law. If they were not trained, then the business would get that fine.
Okay. As far as the alcohol compliance check, are you going into liquor stores as well as bars and restaurants?
Right.
Okay.
Yep. And the system is a little bit different. The tobacco compliance checks run through a statewide program called Wisconsin Wins, and that program has one set of protocol which is similar to the alcohol. The minors usually go in by themselves with the tobacco purchases, as opposed to the alcohol compliance checks, where there usually is an undercover officer that goes in with, or goes in separately, but is in there at the same time, kind of a thing. So, but otherwise, it's pretty similar. So,
what are you finding the mood out there to be? amongst our businesses in Winnebago County. I'm assuming that most of them, whether it be from an alcohol standpoint or a tobacco standpoint, most of them are probably being compliant with the law. Or are they not? Am I wrong?
That would be great, but
I guess I'm wrong.
well, most is correct, but actually
then I'm right.
Right. So, but our non-compliance or our compliance rates are about 75%, which means our non-compliant rates are about 25%, both for tobacco and alcohol.
So we've
in
got
2009.
a long ways to go.
Yeah, so 1 out of 4 businesses will sell to our minors, which is pretty disappointing, but also gives us great opportunity to educate those employers and work with them, and work with those businesses and say, hey, guess what? This is illegal. This is not good for our youth. So we've got our work cut out for us, but it's a good opportunity to to work with those businesses and make sure that they're doing what they're supposed to be doing and following those laws.
Well, when you're finding this 1 in 4 non-compliance, what are the reasons that you're hearing, Emily, as to why they're non-compliant? I mean, are they saying that they haven't been trained?
No.
Or what are you hearing?
A lot of it is as simple as not remembering to ask for an ID. And if they do ask for the ID, sometimes they don't read it correctly, or they're just busy and they're like, okay, I look at it, and then they take it and put it down, and that's usually what it is, is forgetting to ask for an ID or reading an ID incorrectly. Those would probably be the two. Occasionally there might be some other random circumstances, but most of the time it's just human error.
Yeah.
Yeah.
When you ask about IDs, and this isn't you, this is certain stores in town, I mean, they ask for IDs of people who clearly are of age to drink or smoke or whatever. And I have talked to so many people who just find that stupid, annoying. They actually get angry, some of them, about it. And I don't know why stores do that. I mean, if there's a question, fine. But when you see someone, who's very clearly of senior citizen age, probably drawing Social Security, it just seems like, we're being a little overly cautious here. I know you guys are changing your website soon.
Right.
And do you know yet, probably this show is probably not going to air until the first week in April. So will your new website be up by then?
Cross our fingers.
Okay.
Hopefully, yes.
Do you know what the website address will be?
Yes.
Okay, what is it?
rethinkwinnebago.org. So rethink, all one word.
Okay.
Winnebago, all one word.
Okay.
.org.
Okay. And well, I just wrote that wrong. Winnebago.org. Okay. And rethink. Now, is that I just a regular I?
Regular I, yeah.
Okay.
We don't want to mess anybody up.
So people don't
that.
have to be concerned with how your name is actually written. Just rethinkwinnebago.org.
Yep.
Okay. All right. And well, we hope that you'll have it up and running so that people can check it out. And what kinds of things will they see on your website?
Oh, that's why it's taking so long. Because it's going to be basically, we were hoping that it's your one-stop shop for anything and everything tobacco, alcohol, and drug prevention related in Winnebago County.
Okay.
So it's going to have our current initiatives, so what are we working on? Parents Who Host is coming up in the spring, where we remind parents that it's illegal to sell or to furnish alcohol to minors. We're going to have stuff on the smoke-free air law, what websites can you go to if you know of some place that's allowing smoking. There's a complaint website that you could check that out on our website. A little bit of history about the coalition, great facts and other resources and websites related to tobacco, alcohol, and drugs. We've got a good comprehensive list of treatment providers in the area, and then just what's our coalition doing? What are we up to? When's our meeting? What's going on, or what's going on this weekend at Country USA or whatever we're doing. So it'd be great.
All right, good. rethinkwinnebago.org. Very good. Well, we're out of time, but thank you so much for being here.
You're welcome. Thanks for having me.
I hope to have you back in the future as you have other things going on.
We've always got stuff going on.
All right. Good. Good. Well, very good. Thank you. And thanks to all of you. We will see you next time. Until then, take good care. Keep your eye on us. We've got our eye on Oshkosh.